You've asked me to talk about the balance between free speech and dignity on college campuses. This is obviously one of the most electric and hotly contested questions in America today. I thought I would use this time with you, fellow Constitution lovers, really to wonk out about about the historic sources of the First Amendment and where did we derive this powerful principle fought for during the American Revolution, repudiated for much of American history, finally accepted by the Supreme Court in the 1960s, but now very much under debate, that in America, you can only ban speech if it's intended to and likely to cause imminent violence. That's what the First Amendment says, according to the Supreme Court. That's how rigorous the Supreme Court says protections for free speech are. So if you ask me to describe how does the Supreme Court balance free speech and dignity, it strongly puts its thumb on the side of liberty and not dignity. It says that all sorts of speech that violate dignity, including the thought we hate, offensive speech, all sorts of terrible, hurtful speech, must be protected unless it's intended to and likely to cause imminent violence. So shoot Jeff now. This is not the talk I came for. I want to go have a beer. Should definitely be banned. But only if it's a serious and credible threat and it's both intended to lead to my assassination and the rest of the crowd is likely to act on it. Short of that, if you understand it as a joke, my dignity would be very much offended because I've just started speaking. But even that speech would be protected, as would most of the speech that is leading to conflagrations around the country on college campuses. So what I want to do when I say wonk out is just as intensely and compactly, and I hope, interestingly as possible, explore with you where that principle came from in American history, what the founders thought about it, how it fared for most of our history, why the Supreme Court came to embrace it, and then we can talk about whether we should rethink that principle in the age of Facebook and Twitter, when the platforms have more power over who can speak and who can be heard than any king or president or Supreme Court justice, and also whether the balance should be struck differently on campuses, given the particular requirements of the learning environment. Okay, so here we go. It's kind of a dress rehearsal because in September, the Constitution Center is going to launch this new, expanded, thrilling version of the online interactive Constitution that the College Board is going to ask all 3 to 5 million advanced placement students to look at when they study the First Amendment. So what I'm going to try to do is condense the learning that we're trying to put online, and we'll see what you think about it, and then we can talk about it. Okay, so where did that principle come from? Let's begin in 1798 with the first great battle after the Constitution was ratified about sedition. What is seditious speech? It's speech that violates the dignity of the people in power. In particular, the Federalists, led by President John Adams, want to criminalize seditious speech that brings contempt or disrepute on any president of the United States, who happens to be a Federalist, but does not forbid similar calumny against the vice president, who happens to be a Republican, Thomas Jefferson. So it was clearly an effort to insulate Adams from criticism by Jefferson, who's running against his party in the 1800 election, and we would view it today as blatant viewpoint discrimination in the modern jargon. Under the British common law of the time, sedition could absolutely be criminalized. Criticizing the king led to all sorts of prosecutions and convictions. In Britain, truth was no defense. In fact, the greater the truth, the worse the offense, because that meant the greater the indignity. And there are all sorts of famous prosecutions in colonial America against people who criticized colonial governors, including John Peter Zenger, the printer who published seditious pamphlets criticizing the king and was famously defended by Andrew Hamilton, the Philadelphia lawyer, who was so successful in persuading the jury to nullify the sedition verdict that he won the sobriquet Philadelphia lawyers for being unusually clever. So the Sedition Act is passed, and all sorts of people are convicted under the Sedition Act for criticizing President John Adams. And indeed, a Supreme Court Justice, Samuel Chase, is impeached after the election of 1800 for not only convicting these Federalists, but for haranguing them from the bench. And he was also drunk at the time. And eventually the Senate acquitted on the grounds that you can't remove a Supreme Court justice from office because you disagree with his constitutional views. John Marshall testified in favor of Chase, but that's how contested things were at the time. The Sedition Act is passed, people are convicted under it, but Jefferson and James Madison argue that the Sedition Act is unconstitutional. And they write two classic works of American constitutional poetry, the Virginia and Kentucky resolutions, arguing in part that prosecuting people for criticizing public officials violates the natural rights of speech and conscience. What are the natural rights of speech and conscience, and why did Jefferson and the other founders believe that the rights of conscience are unalienable? They're among the unalienable rights that in the state of nature we are endowed by our Creator. In other words, we know from the Declaration that Jefferson believes that all men are created equal. They are endowed by their Creator with certain unalienable rights. What is an unalienable right? It's a right that I can't alienate or surrender to government when I move from the state of nature to form civil society. The Declaration of Independence says that to secure these rights, governments are instituted among men, and that whenever a government threatens rather than securing the rights that people retain, it's the right and duty of people to alter and abolish it. So the quintessential unalienable right is the right to alter and abolish government, or the right of revolution, whenever government threatens retained natural rights rather than securing them. But why are the rights of conscience the quintessential unalienable rights? Now this is so cool. If we go to the interactive Constitution, we can look at the Revolutionary era state constitutions that Madison relied on when he wrote the Declaration, and that Madison relied on when he wrote the Bill of Rights. So this is called Writing Rights, and we're at the First Amendment, and the best place to look is the New Hampshire Constitution of 1783. Madison is cutting and pasting among these. Among the natural rights, some are in their very nature unalienable because no equivalent can be given or received for them. Of this kind are the rights of conscience. Every individual has a natural and unalienable right to worship God according to the dictates of his own conscience and reason, and no subject shall be hurt, molested, or restrained in his person for worshiping God in the manner in season most agreeable to the dictates of his own conscience. You have to realize what people of the Enlightenment the founders are. They're reading people like Thomas Hutchison and Jean-Jacques Burlamaqui. And Jefferson writes in his Bill for Religious Freedom in Virginia that our opinions are the product not of force or violence, but of they're the involuntary product of the evidence presented to our reasoning minds. That's what Jefferson says in the Bill for Religious Freedom. And he's reading Thomas Hutchison, who says that we cannot command ourselves to think as we or anyone else pleases, because our opinions are the involuntary product of evidence operating on reason. You see what a profound thought that is? I can't help whether I believe in God or not, or whether I want to criticize the king or not, because those beliefs are the product of my reason rather than my passion. And therefore I can't alienate my right to reason to you when I form a government, even if I wanted to, because I can't help what I think because it's the product of my reason. So that's why the rights of conscience are unalienable, and that's why conscience and belief are the quintessential unalienable rights. And that's exactly what Jefferson and Madison say when they argue that seditious laws are unconstitutional, because if people think that the king is a knave or a fool, those political beliefs are the product of their reason, and they are by nature unalienable. So it's the very essence of American political thought comes back to this central free speech battle. Nevertheless, the colonists are still caught up in the British common law at the time, and the prosecutions are allowed to go ahead, although Jefferson, when he becomes president after 1800, pardons most of the people convicted under the Sedition Act. And the verdict of history, as the Supreme Court said in the Times and Sullivan case in the 60s, was that the Sedition Acts were unconstitutional, even though they weren't recognized as such at the time. So what event was it that changed our understanding of sedition and free speech and persuaded the Supreme Court to forbid the prosecution of sedition. It was another controversy over criticism of the government, and it took place during World War I, when Congress, in the middle of the red fever stirred up by World War I, passed another Espionage Act called the Espionage Act of 1917. This is very much relevant because Julian Assange was just indicted last week for password hacking, computer crimes, when he induced or allegedly aided Chelsea Manning to try to break into government computers. Some fear that Assange could be prosecuted under the Espionage Act of 1917 for the truthful publication of information harmful to the government. The language almost sounds exactly like the language in 1798, and it was passed in 1917. So 1917, the war fever is going, and after the war is over, all sorts of critics of the war are prosecuted and convicted under the Espionage Act, including Eugene V. Debs, the socialist candidate for president, who runs for president from a jail cell in 1920 because he's made a mild speech criticizing the war. He stood up and said something like, "Don't enlist in the war. This is a war for the capitalists against the people." And for that, he's criticized, he's indicted for harming the interests of the United States and offending the dignity of the government. And the Supreme Court, I think the Supreme Court, in fact, upholds the conviction overwhelmingly. So the standard understanding of the law at that time is prosecutions for sedition are fine. But over the summer of 1919, two great Supreme Court justices changed their mind about the prosecution of sedition. And they are Oliver Wendell Holmes and my hero, Louis Brandeis. And they're upset by the prosecution of dissenters, and they've also read a brilliant article by a law professor called Zechariah Chafee, who articulates the principle that speech should only be banned if it's intended to and likely to cause imminent violence. And Holmes comes to embrace that principle in an inspiring opinion called the Schenck case, where he embraces the metaphor of the marketplace of ideas. And he has just served in the Civil War, where he was wounded 3 times and almost died. And he went into the Civil War as an abolitionist, but after seeing, being at Appomattox, where 23,000 people were dead or wounded, he was so despairing about the possibility of reason to prevail over deliberation that he thought basically the majority should always be able to express itself and pass any law, or else open violence would result. And the only exception that he made for that were laws that tried to squelch the marketplace of ideas, because he said that that could lead to open violence. So it was a very cynical and cool-eyed view of free speech. Holmes had no special faith that truth would prevail, but he thought that the only alternative was violence. Brandeis had a much more inspiring and affirming and positive view of free speech. His heroes are Jefferson and 5th century Athens. Brandeis spends the summer of in particular 1925, reading a lot of Jefferson. He reads the Bill for Religious Freedom, which I quoted to you from, and he reads Jefferson's inaugural address, we're all Republicans and we're all Federalists, and he becomes very moved by natural law theory, which says that we all have certain faculties ranging from passion at the bottom to reason at the top. And the entire Constitution is constructed to ensure that reason rather than passion will prevail by slowing down deliberation so that hasty and impetuous factions or mobs can dissipate before they have the opportunity to do damage. Brandeis is thrilled to read from Jefferson that passion will dissipate as long as there's time for deliberation. Time is the crucial element. And he has tremendous faith, as Jefferson does, that given time, people can cultivate their faculties of reason and exercise their unalienable rights of conscience. And then Brandeis also reads a book called The Greek Commonwealth by Alfred Zimmern. And he becomes inspired by Pericles' funeral oration and by the idea that in 5th century Athens, it was an enclave, a haven of reason, where in the agora, in face-to-face deliberation, people could exercise their faculties of reason. So he distills all of this learning into the Whitney and California concurring opinion. And I think it's the most beautiful free speech act of constitutional poetry in the 20th century. Justice Kagan, Justice Ginsburg all consider it the greatest statement of free speech of that century, as do many conservative justices. And as a party trick, I think I can recite a section from Whitney, because I wrote the Brandeis biography, and I've done it 1 or 2 times. We'll see how I do. But Whitney is an amazing case. There's a woman, Anita Whitney, who stands up at a meeting in California denouncing lynching and Klan violence. And she's making a speech in favor of civil rights. And she's indicted for thinking of assisting to possibly conspire to aid the California criminal syndicalism law. It's like a whole bunch of prefatory clauses. Basically, it's allegedly a Communist Party meeting. She's not a member of the Communist Party, but the fact that she's appearing at this meeting denouncing lynching means that she might be helping communism, which could lead to the goal of achieving the communist goal, which is supposed to be to overthrow the US government. So it's a very attenuated bit of guilt. And she's convicted under this California syndicalism law, which is like a sedition law. And the majority of the Supreme Court upholds her conviction. And Brandeis writes a separate opinion, objecting to the majority's reasoning. And it's the most beautiful statement of his Periclean and Jeffersonian faith. And he begins by invoking not the founders and Madison and Hamilton and the framers of 1787, but Jefferson and the revolutionaries of 1776, because he's been reading Jefferson the previous summer. Here is Brandeis in Whitney. Those who won our revolution believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They valued liberty both as an end and as a means. They believed liberty to be the secret of happiness and courage to be the secret of liberty. That's a quote from Pericles' funeral oration. They believed that liberty to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth. That without free speech and assembly, discussion would be futile. That with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest threat to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government. You see how much, that's to Brandeis, and it's just, you see how much, every sentence in there is meaningful, and it just encapsulates this astonishing Jeffersonian Periclean faith in reason. As long as there's time enough to deliberate, the best answer to bad speech is good speech, to hate speech is counter speech, and Brandeis has faith that we can cultivate our faculties of reason and that reason will ultimately prevail. And that's where we got the principle that Brandeis said that speech should only be banned if it's intended to and likely to cause imminent violence. Because short of that, usually there's time enough for reason to prevail. If there's a danger of imminent violence, then you can step in, but as long as there's time enough for deliberation, then deliberation should be allowed. That's the idea. You can't attribute it to all the founders because but it was the Jeffersonian idea. And it was Madison's idea, and it was Brandeis's idea, and it's rooted in the theory of natural law that inspired the founders, and it was led to the most inspiring free speech opinions of the 20th century. So the amazing thing about this Brandeis concurrence is that it was eventually adopted by the Supreme Court. And in 1969, in a case called Brandenburg versus Ohio, the Supreme Court itself embraces the idea that speech can only be banned if it's intended to and likely to cause imminent violence. And the amazing thing about Brandenburg is it's a case involving the Ku Klux Klan, and as many of you know, and it's a guy who stands up in a Klan uniform at a Klan rally and issues some crazy racist speech saying, unless there is protection for free speech, then the white people might take revengeance. That's what he says. and he's indicted under a law saying that that could lead to violence. And the Supreme Court looks at the facts and says, no, this is horrific, hateful speech. The Klan is appalling, but there's no danger of mob violence. No one is about to respond to this speech, and therefore there's time enough for deliberation. And the court said, we have faith that anyone who heard the speech would have time to evaluate it and not act violently, and therefore it should be protected. So that was a real high watermark for the protection of hate speech. And once again, you're asking, what's the balance between dignity and free speech? The speech is an appalling offense against dignity. It's racist speech, but the court says, nevertheless, it has to be protected. And then what's so amazing about the American free speech tradition is that bipartisan majorities of the Supreme Court continue to embrace it. Liberal and conservative justices, by overwhelming majorities, 8-1 in most cases, or unanimously, agree that the Constitution protects the thought we hate. And the most recent examples of really appalling hate speech being protected by the court are the Westboro Baptist Church case. You know, those awful protests at military funerals by members of the Westboro Baptist Church who believe that war is punishment for the Army's toleration of LGBTQ people. It's something like that. And they're going around and making hateful protests denouncing the fallen soldiers who are being buried. And they're prosecuted under local tort laws and privacy laws on the grounds that people should be able to conduct military funerals without having racist and homophobic protests. And the Supreme Court, by an overwhelming majority vote, says no, this is indeed appalling homophobic speech, but there's no threat of imminent violence. It's not intended to or likely to cause imminent violence. It's a legitimate political protest, and therefore it has to be protected. And that just goes on and on. It's one of the most important areas of bipartisan agreement on the Supreme Roberts Court today. Many of the cases, some of the cases are unanimous. Sometimes it's 8-1. Justice Samuel Alito is a more traditional conservative who favors dignity and privacy over free speech. He wrote his senior thesis at Princeton about privacy and dignity. And in cases involving horrific crush videos where Congress banned these fetishists who like to crush animals, the Supreme Court 8-1 says, no, Congress, you can't do that. It's appalling speech and really harmful and offensive, but it's protected by the First Amendment. Alito objects on the grounds that it's legitimate to protect people's privacy and dignity. Alito embraces a much more European notion of free speech. And the subject you asked me to talk about is liberty versus dignity. There's a brilliant article by James Whitman saying two concepts of privacy, liberty versus dignity. And he notes that in Europe, privacy is protected in terms of dignity. And it is a crime in Germany to give someone the finger on the highway because it offends people's dignity. Imagine how that would fare, on 676 or something like that. And it goes back to this old honor culture in Europe where everyone knew their place. So in Europe, if you're an aristocrat and someone insults you and they're an equal, you challenge them to a duel. If they're an inferior, you hit the person who insults you with a cane, and you choose the wood of the cane to signify exactly what the social status of the person who's insulting you is. This only works in a world where everyone knows their place, a world of great hierarchy. In America, it's completely different. We are not supposed to have place, and we're not supposed to be in one box rather than the other, and we protect privacy under the Fourth Amendment in terms of liberty. You can't come into my home, which is protected against unreasonable searches and seizures. But dignitary offenses usually are not actionable. The most dramatic example of the clash between the European and American conceptions of free speech can be found online in the new right recognized by the European Court called the right to be forgotten on the internet. It comes from the French droit à l'oubli, or the right of oblivion, which is completely French, I want to be forgotten, all the French think, and the Americans all want to be remembered. But it's an amazing right, because if we were in Europe right now and you were tweeting, Jeff is totally going on too long, now it's definitely time for a beer. After the show, I could sue you for violating my dignity, and not respecting my incredibly fascinating speech. And then Google would have to make a bunch of decisions. First, am I a public figure? Second, is your tweet on a matter of public, scientific, artistic, or literary merit? And if Google guessed wrong and were second guessed by a European privacy commissioner, it would be liable for up to 2% of its annual income, which I think last year was something like $70 billion. So this obviously concentrates the mind, and as a result, Google has removed at least 42% of all the takedown requests it's received for undignified tweets in Europe, including requests to take down articles about the right to be forgotten itself. So you have a sense of the cost of heavy dignitary enforcement, because it does put some officials, whether they're judges or lawyers at Google or privacy commissioners, in the job of deciding how to balance the free speech of the speaker against his or her dignitary interest, against the public interest in your speech. And all of this came to a head, I think this may be one more beat on Brandeis, in Brandeis's famous article on the right to privacy. The most famous article on the right to privacy ever written was in 1890, and there's a new technology, the Kodak camera and the tabloid press, which is ensuring that gossip that used to be whispered from the closets is now shouted from the rooftops. And Brandeis and his law partner, Charles Warren, write an article saying that the law should provide a remedy for both public and private figures against gossip that offends people's dignity. They were apparently upset by invasions of social privacy in the Boston tabloids. But they look to American law and they can't find any cause of action, because American law, unlike European law, as we just found out from James Whitman, and as they recognized a century earlier, provides no remedy for offenses against honor. And therefore they tried to create a whole series of complicated torts. They're known as the Brandeis Torts. They sound like a delicious dessert, but they were a kind of unsatisfying legal remedy for dignitary offenses. They include intentional infliction of emotional distress, intrusion on seclusion if you plant a camera in someone's room without telling them, false light, you use someone's image to advertise something, or any other speech that might be highly offensive to a reasonable person. The problem with the Brandeis Torts is the same problem that the right to be forgotten showed us, which is namely, once you start invoking dignity to squelch speech, you can squelch a lot of speech that's in the public interest. And public figures started demanding that their speech was being offended by this gossip, and courts had to strike this balance. And a few years later, Brandeis changed his mind about the proper balance between free speech and privacy. He wrote to his wife, Alice, I've reread the article, I don't think it's as good as I thought it was. He becomes much more interested in liberty versus dignity. He decides that sunlight is the best disinfectant, transparency the best policeman, and he comes to embrace the immortal notion of speech that we started off with, namely that speech can only be banned if it's intended to and likely to cause imminent violence. So that's my encapsulation of the way American law has struck this balance. It begins with the Sedition Act and the natural law theory of Jefferson and Madison. It comes to a head in the sedition debate in 1917. It takes form in the mature opinions of Holmes and Brandeis, and it's finally embraced by the Supreme Court in the 1960s, and it continues till today. Where does that leave free speech online and on campus? On campus, you are a public university. You are bound to respect the First Amendment. I'm eager to hear from you about how you have resolved these disputes between free speech and dignity, but formally you're required to protect speech unless it's intended to and likely to cause imminent violence, or the regulations are legitimate regulations of time, place, and manner. So there are all sorts of really complicated questions, as we all know, about a heckler's veto. What if you guys started standing up and try to shout me down? You're not supposed to be able to do that. You can protest silently, you can walk out, you can say I'm terrible, but you're not supposed to be able to shout me down. Disinvitations are a tough question, but generally universities can decide who to invite or not. Free speech zones are being challenged. Generally, you can't just carve out one enclave for speech and have that be the only place to speak. speech is supposed to pervade. And yet the classroom is different, and you can make rules to ensure that pedagogical purposes are solved. So broadly, public universities have been very constrained by the First Amendment. Private universities were, until about 2 weeks ago, in a totally different bucket. They are not bound by the First Amendment. The First Amendment says Congress shall make no law. It doesn't say a private university shall make no law. It also doesn't say Mark Zuckerberg shall make no law. And therefore, private universities, in theory, could ban speech on the basis of dignity or do whatever they liked. But the Trump administration just issued an executive order saying that private universities are at risk of losing federal funds under Title IX if they fail to follow their own speech policies. And it also encouraged a series of federal agencies to develop guidelines for what speech policies should be followed in the future. I'm just going to be neutral and descriptive here rather than telling you what I think about the current stuff, but I can say descriptively, the executive orders have been questioned by some conservative and libertarian as well as liberal organizations, basically on the grounds that government bureaucrats shouldn't be in the business of deciding who's violating their own free speech policies. These are really tough questions about whether disinvitation does or does not suppress free speech, and if the Department of Health and Human Services is going to be evaluating these issues, it runs the risk of political manipulation. Also, if a university certifies that it is following its own policies, and the government later decides it's not, it's liable for up to millions of dollars of fines under the False Claims Act. So it could be like really serious money at stake, a very serious government intervention in deciding what upholds the First Amendment and what doesn't, which is why Robert Zimmer, the very eloquent president of the University of Chicago, which is responsible for the Chicago Principles, which basically encourages private universities voluntarily to respect the First Amendment, has criticized this executive order as well. The case on the other side, I guess the case for it is what's wrong with making universities follow their own policies. And since public universities have to protect free speech and private universities also are in the business of promoting the free exchange of ideas, why shouldn't they respect the First Amendment too? The most significant free speech disputes now are taking place online. And the question of what Facebook and Google should do when it comes to speech will have more influence over how all of us actually speak than even what our universities do. This is a really tough question. Facebook and Google and Twitter have adopted a kind of unsatisfying mashup of European and American approaches to free speech. They have user guidelines that prohibit people from criticizing groups on the basis of race, gender, and religion, but don't prohibit the criticism of individual religious leaders or of individuals on the basis of those characteristics. So to show you how complicated this is, a few years ago there was a video called The Innocence of the Muslims, which this sort of crude video that the president of Egypt said had led to riots in the Middle East, and both he and President Obama called for YouTube, which Google owns, to ban the video. They looked at the video and found that it criticized the Prophet Muhammad but didn't criticize Islam, and therefore left it up. And later it turned out the Benghazi riots were caused for other reasons, so it seemed like a better free speech decision than that of President Obama and the President of Egypt. But where did this distinction between criticizing a religious leader and criticizing a religion come from? It came from a 28-year-old Bowdoin graduate who majored in anthropology at Bowdoin, went on to run the help desk at Facebook at a time when it was a startup and there were basically 5 people working for the company. And then the company got a little bigger and Facebook said, hey, we need some free speech guidelines. And he vaguely remembered reading John Stuart Mill in college and somehow extracted from Mills on Liberty this interesting idea that you can criticize an individual religious leader but not a religious group. Not exactly clear where that comes from in Mill, but it was a good college try to come up with some speech policies on short notice. But it shows you how incredibly powerful these often young, often untrained, sometimes even non-lawyers at the companies are. And now, this is the year when the whole edifice exploded. And Facebook got so hammered for both its privacy decisions and for its free speech decisions, for not regulating fake news, for its role in the election, that Facebook is now considering creating a Supreme Court for Facebook. And it's thinking of commissioning a group of law professors basically to make the decisions for it. They think, we don't want to do this. We're getting hammered for it. You guys tell us what to do. Like the Seinfeld Ninja Turtles, why don't you just tell me what you think? You know, they don't want to decide it themselves. I think I'll leave it to you. I'd like to know your opinions about whether or not a Supreme Court for Facebook is a good idea. If so, what principles should it apply? Well, let's just start the discussion there, because that's really what we're here to talk about. Do you believe, first, that creating a Supreme Court for Facebook is a good idea? And should the Supreme Court for Facebook apply the American free speech principle that speech can only be banned if it's intended to and likely to cause imminent violence? It can't do that in France and Germany, where Holocaust denial is illegal. Holocaust denial is clearly protected under the American First Amendment, but Facebook has to obey local laws of all the countries it operates in, so it's obliged to apply those laws when they're clear. But here in the US, do you believe that the new Supreme Court for Facebook should apply the First Amendment principles that we've discussed or not? That is where I would like to start the discussion, and thank you so much for listening.